Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Networks with the Federalist Society. Today, we're excited to host Best Practices in Defending Against Mass Consumer Claims, featuring Matthew Turetsky and Colin Vieira. Matt is Deputy General Counsel and Head of Litigation at Kraken. He oversees all litigation involving Kraken and its global affiliates. Matt was previously Director and Associate General Counsel at Coinbase, where he led the consumer, commercial, and international litigation teams and oversaw significant litigation operations. One of these appeals, Bielski v. Coinbase, confirmed at the Ninth Circuit that pre-arbitration dispute resolution procedures are enforceable, and at the U.S. Supreme Court, mandated stays pending arbitrability appeals through the federal court system. Colin is the head of Imrostal's Mass Arbitration Practice Group and the head of its Data Privacy and AI Practice Group. Colin is known as a leading lawyer in the mass arbitration defense space, and he has helped clients respond to more than 250,000 individual demands for arbitration. As defense counsel, he is known for his innovative defense strategies, including major fee-shifting awards for his corporate clients against the plaintiffs' bar. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. In order to receive continuing legal education credit for this webinar, you must attend the Zoom webinar and have access to the chat box. This event's accreditation is predicated upon interactivity and verification measures that are only available via the webinar. If you join via audio, calling in, SIP, or H323, you will not be eligible to receive CLE credit. At some point during the presentation, we will be posting a CLE code in the chat box, at which point a slide will be posted on the screen to alert you. Write this code down because you'll be required to provide it at the conclusion of the webinar when completing your attendance reporting form. Written materials for this event were emailed to all registrants prior to the webinar. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. So with that, we're going to start by turning things over to Matt, who's going to talk about how, in his view, we are now in the third generation of mass arbitrations, and what that means for companies facing mass consumer claims.
Thanks so much, Marco. Before I begin, I should probably just give the disclaimer that the views that I'm going to share here are mine, and they're not the views of my employer, Kraken. With that, let me give you a sense of what I'm thinking about when I think of the three generations of mass arbitration. So the original mass arbitrations came about early on, and one of those was the famous DoorDash mass arbitration. And that happened in the late 2010s, around like 2017, 2018. And it came to, it was a bit of a surprise, after years of relying on arbitration agreements and class action waivers, the defense bar had really not seen anything like a mass arbitration where 10,000 individual claimants represented by a single law firm would all file individual arbitrations with a single arbitration panel, more or less asserting the same claim. So that caught the defense bar by surprise. And then there was the second generation where consumer-facing companies began to deploy terms in their customer-facing user agreements, employer agreements as well. You began to see things like batch arbitration provisions and bellwether provisions. And these mass arbitration specific terms were then litigated in cases like Heckman, Stars, Bielski, and that litigation is now beginning to settle. There's now a body of law that seems to more or less be developing around which of these terms are problematic and which of these terms are enforceable. And now we're in what I think is the third generation of this practice, where it really has become, for better or for worse, a real practice area. And plaintiffs' firms and corporate defendants are increasingly litigating these mass claims at scale in arbitration rather than writing settlements at some point before trial. And so I think that that's where we are right now. Colin, I should turn it over to you.
Yeah, I completely agree with that formulation, and the only two things I would add to it is, just like age cohort generations, there are multiple generations alive at once, and so I still think we do have a bit of the second generation and the third generation starting up in the mass arbitration space, and there's still an effort, in particular among some of the either better funded or more aggressive plaintiffs bar, to push back to the prior generations. So, Heckman is one of those issues. For those who haven't read it, in particular, take a look at the concurrence in that decision. It has not really had a lot of legs in subsequent decisions so far, but there's a significant effort by the plaintiffs bar when it feels justified in making the gamble, so to speak, to try to undermine the solutions that companies have implemented to actually arbitrate on the merits the way that really is envisioned by good faith counsel on both sides, and to go back to a world in which these are all settling due to fee pressure. So that previous generation is not quite dead yet. On the third generation, there's also the difficulty of what the ideal is and what the reality is to some degree. Matt, I know you have also seen, for example, the AAA infographic that was put out summarizing the 2024 mass arbitration results. I think it came out in May 2025. So there's a bit of lag time, and it'll be interesting to see if we get that again in 2026. But that was published with a lot of fanfare from AAA about how great it looked, and it looked horrifying to me. It was a shockingly small number of total mass arbitrations actually filed. It was like 80 or 82, I think, the entire year. Now, of course, many more get sent to a company but not filed. But it was like 80 total mass arbitrations for the whole year, about 250,000 individual cases. I think 7,000 something closed in the entire year, and 1% of those had an award. I mean, that to me is atrocious, right? That indicates that there is a mass amount of just frivolous claims being filed, designed to impose settlement leverage. I'm really curious to see how those numbers change in 2025. My guess is that there's going to be a much larger number of filed arbitrations and claims. I hope that results in more being awarded one way or the other, or ones that are actually settling based on some kind of bellwether process and not a fee process. But with uncertainty about how those are going to be administered, I hope the third generation will turn into a scenario where we are getting more that are resolved on the merits or reasonable expectations of the merits. But I still think we have a ways to go. We don't know the numbers from other arbitration providers. They're not published in the same manner as AAA's are, but maybe there's pressure to do that this year and catch up. So Matt, I don't know if you want to comment on any of those stats, but if not, I want to ask you about, given the reality of the third generation coming to the fore, some of the details about the pre-arbitration process.
Yeah, so look, there are a lot of things you could do in advance of arbitration, things that you could do to your terms of service or user agreement or employment agreements, a whole menu of options, including things like, do you want to use a batch arbitration provision, which makes a lot of sense, I think, if you're of the mindset that we're really going to litigate these claims if they get filed in arbitration. I think the challenge with using something like that is that the plaintiff's bar, anytime you include any of these options, you should expect that you're going to be spending money and time on litigating the enforceability of these provisions. But batch arbitration provisions, I've seen those widely upheld. Bellwether provisions are a little more tenuous, but batch arbitration provisions certainly on the menu of things you can consider. Another is pre-dispute resolution terms, and this is something that I saw over at Coinbase in the Bielski case. The whole issue at the Ninth Circuit was whether Coinbase's pre-dispute resolution process was unconscionable and thereby rendering the rest of its arbitration agreement unenforceable. The Ninth Circuit held that it was plenty enforceable and sent the case back down to the district court and back to arbitration. So, building in a pre-dispute resolution term, absolutely something that you can consider. I think Uber's provision is something worth looking at. I kind of cite that as like the gold standard if you can do it, having a process where you and the plaintiff are going to appear on like a teleconference or something to try to resolve things before it goes to arbitration. Obviously, that's resource intensive, but I think that's certainly something that could de-escalate, a mass arbitration threat. Last is, an explicit incorporation of Federal Rule of Civil Procedure 9b into the consumer terms. This goes to some of the points you were raising, Colin, around some of the tactics that maybe some members of the plaintiffs' bar are employing by having that 9b hammer explicitly in the arbitration contract between the company and the consumer. You give yourself another out when you're dealing with folks who are deploying those tactics. So I think the challenge, though, is figuring out what's right for your company and also balancing that against potential unconscionability challenges, or for those of you in private practice, what's right for your clients and balancing that against those challenges.
Yeah, I completely agree with that. I know people associate you with Bielski, and they should. I have to give you extra credit every single time we talk about Bielski.
Sure.
I did an econ graduate program while in law school, and one of the common problems you often deal with is how do you incentivize companies to undertake actions with positive externalities. And, there's always proposals by economists to ignore the Constitution, just reimburse them, sort of tax everybody else. If you could do that, Coinbase should get paid by everybody who has mass arbitrations for Bielski, because the pre-arbitration processes are fantastic. And as Matt mentioned, there are variations of these, and you can tailor them to what suits your company best. But the general idea is, before letting the claims proceed to arbitration and letting the attorneys from the plaintiff's bar really take over, you can slow that process down and actually resolve them in an appropriate way if there is liability, and just understand what the facts are so you can reasonably investigate them. That was really hard to do pre-Bielski. And again, Ninth Circuit Bielski, not Supreme Court Bielski. Both good, right, but you got to cite the right one. Yeah. But the thing I have often seen, I've even seen some companies who had informal dispute processes and then remove them because they basically didn't want to do them in certain cases. To me, that's completely unnecessary, because you can just put in your term that the party receiving a demand has the right to demand an informal conference before arbitration is filed, and then you can waive it on an individual basis. So to me, you want to give yourself the option at least to do that. On the point, Matt, you raised about preparing for the reality that more of these are going to be filed and hopefully arbitrated on the merits when justified. I think for companies that have the resources to do this too, it's really important to start planning ahead for this. This is probably a major statement against interest as outside counsel. But if you are a company that knows you are going to be dealing with consumer claims for a long time and you're going to get some every year, you should really be designating someone internally, at least one person, to start preparing for how you are going to administer informal dispute conferences. Because I have been brought on, ad hoc, sort of in desperation, when a 30-day window is going to expire, and we've got to hire a vendor and a call center, and it's very expensive and it's a lot of attorney time. But if you want to prepare for these going into the future, it's going to be a lot more efficient, a lot less expensive, a lot less subject to risk, including of having a third-party vendor cause an issue, which I've seen before. I've seen call centers just totally botch these processes. To have an internal process for how you administer it, and having a written policy for that too is helpful in the event you do get an extreme unconscionability challenge and someone claims this is really just an artifice to try to prevent claims from being filed. If you can say, no, here are examples when we get claims, how we efficiently administer them, settle them when appropriate, don't settle them when not appropriate. It's a huge boon. And in connection with mandating these processes, this is something that I've not seen done very frequently still, and I do not know why. We confirmed a few of these awards in court recently to try to make sure the defense bar could cite them. Like you can impose attorney fee shifting for violations of the pre-filing process. It is a huge benefit. And those attorney's fees can be enormous. So going back to that AAA infographic about 2024, again, I don't recall the exact number, but I think the largest award listed for the entire year in a consumer case out of a mass arb was something around $35,000. So that was probably statutory claim with attorney's fees most likely for a consumer among those thousands of cases. We've had multiple cases during the last calendar year where we got more than that on the defense side by getting a attorney fee shifting award against plaintiffs' counsel for violating the informal dispute process. Because yes, the individual consumer on occasion might go ahead and breach that. You do get these kind of crazy pro se people on occasion. But realistically, the average person bringing a claim, they don't know what they're doing. They just clicked an ad online. It's the plaintiffs' bar behind it. And so we have found arbitrators very willing to punish plaintiffs' counsel for violating what Bielski endorsed as a laudable process. And it's very beneficial if you're the company as well, because realistically, there are probably pretty few cases where you really want to enforce an award against a consumer. So it becomes kind of toothless if you don't want to do that. But I personally have no qualms about levying a plaintiff's counsel's bank account if they don't pay you 50 grand in attorney's fees, for one arbitration. So, these can really, really add up, but I think you've got to prepare for them in advance. Matt, I don't know if you have any other thoughts about.
The only other thing I want to just to put some more gloss on that is like you really got to tailor. And I'm speaking more as an in-house lawyer here rather than an advocate who's carrying the sword into these proceedings. But you really got to tailor these terms to what makes sense for your client. Like if going back to Coinbase, I think the terms that Coinbase has make sense for Coinbase. Going to Uber, you look at the terms that Uber has. Uber has a different process. Like that makes sense for Uber. Pick your company and look at their terms. My guess is the in-house lawyers at each of those companies are thinking, what makes sense for our company? What will actually work in our org? What will work for our business? What's our business's ultimate objectives? And look, if you can do something like having live conferences in the hopes of resolving these things before they go to formal arbitrations, I think it's great. But for some companies, like that's just not realistic, and you may want to tailor this process differently. And of course, this is not necessarily going to stop a mass arbitration from proceeding, especially now that many of the providers have instituted mass arbitration terms. And that goes to, I guess, what we could transition to now, which is the developments that we're seeing on the provider side. Colin, you want to kick that off?
Yeah, I do. Just as we go there, I do want to mention one thing too, for those who do have these processes, just as a word of caution, because I have not seen any public filings on this yet, and I'm very concerned that companies are going to get hit with this, and there'll be more to come. If you have designated an agent for service of process to receive your arbitration demands, strongly reconsider that. I can talk to folks offline about this, but there is one, at least, that is taking the position that a surcharge applies to receipt of every demand. So I've got a situation right now with an actually fraudulent mass arbitration by a sanctioned attorney, totally fake claims made up, sent to a service of process provider who now wants to charge several $100,000 to a company for receipt of those demands. And on the legal position that they are obligated to process them and couldn't just call you up and say what they received. So I just want to flag that for those who put this into effect years ago. I would strongly reconsider the method in which you receive those, because you do not want to add insult to injury by getting silly claims and now having a contract dispute potentially with your agent. So on the provider developments, these have been fascinating and ever changing. I'd say that my my main word of caution about providers in general is to try to understand, both from fellow in-house counsel that you have good relationships with and your outside counsel, what is happening in practice, because it often contradicts the rules as published. That's hugely problematic, but it's true. The general trend over the last few years has been that jams became the most problematic institution to use for mass arbitrations because they had no mass arbitration rules and they had massive fees. So this is where all these infamous cases arose. That caused an enormous exodus to AAA when AAA implemented mass arbitration rules. JAMS has now implemented its own mass arbitration rules that, without going too in the weeds on this, essentially the main difference is charging per arbitrator rather than charging per case. And so in large cases, the JAMS fees are now, at least putatively, lower than the AAA fees. And there's a huge shift back because of inconsistencies in the way the rules have been applied in some cases at AAA that have caused a lot of frustration. Meanwhile, there are other arbitration providers as well, besides the big two. You don't want to use New Era, just based on Heckman. But there are other ones that are doing, really pushing for reform efforts for mass arbitration. There are just fewer data points, which I think is something that in-house counsel has to think about when they're doing this. I would call the providers, ask appropriate questions. You don't want to do it in connection with the case and have an ex parte issue, but if you are choosing one ex ante, consider it. So, besides JAMS and AAA, here's my super high level summary of these. FedArb is basically JAMS-like panel. So it's sort of more sophisticated panel than AAA, not just random attorneys, but a lot of former judges. And it's an MDL style process. That's sort of their main marker. NAM, its processes are not that different than sort of the AAA mass arbitration process, but they actually have less of a fee differential. And so there's a greater cost to the plaintiff's bar, comparatively speaking, to bring claims in NAM. But their panel is just generally less well known. If I see a NAM list, it's much more difficult for me to ascertain what these folks have decided previously. ADR services is really sort of a California service. My general experience is that they actually tend to be more consumer friendly on the merits, and they sort of decrease in popularity as there have been reforms. But I've got more thoughts. Let me go to Matt, though. I know you think about this a lot, and in your former role.
That's true. And I suspect my perspective is a little different than yours, Colin, because of the nature of my role. So as an in-house litigation attorney, one thing that I'm thinking about is what provider would I recommend that my client use? That's one decision that I'm thinking about. The other is, how is this going to play out in litigation once the shots get fired? So I'm thinking about process and enforceability. And on those two factors, I think of the providers as sort of living on a spectrum. You mentioned New Era, and obviously the Heckman decision was very problematic for New Era, but I've got to give New Era a lot of credit. At a time when nobody in the arbitration space was meaningfully updating their rules to address the developments of the mass arbitration space, New Era stepped into the arena and put forth a set of mass arbitration rules. Now, the process itself came under tremendous scrutiny in Heckman, and that is what it is. But I got to give them some credit, and I put New Era on like that far end of the spectrum in terms of innovative, but also, I would think about New Era in terms of that court scrutiny and ask myself, is it so innovative that maybe it's not going to survive court scrutiny on certain terms? And so you want to keep that in mind when you're looking at those providers. And on the other end of the spectrum, there are providers like AAA and JAMS that are huge. They're tried and tested. I think it was in the Heckman decision where they were explicitly mentioned as, examples of the tried and true. And I know we've got members of the arbitration provider community here on this webinar. While AAA and JAMS are they now are they have put forward mass arbitration terms. My criticism of both of those tribunals would be that they were late to the party. The ship had already sailed on mass arbitration by the time their mass arbitration terms came out. Now that we have them, though, I think there's now this spectrum of providers. Everyone has some approach to mass arbitration. So that is now, them being late to the game, I think is now a historical fact. And when I think about us being in the third generation of mass arbitration, I think at AAA and JAMS, seeing their mass arbitration terms getting tested, seeing how those mass arbitration terms map on to company terms of service, and how that dynamic plays out in any given mass arbitration campaign, that's what we're going to see play out over the next few years. And I think each company, has to decide where do they want to sit on that spectrum. And of course, if you're not satisfied with an arbitration provider, you always can make a change. So you really just got to stay plugged in with the changes that the providers are making. And one suggestion I'd have is engage directly with the providers. A lot of the providers will talk to you, or talk to your outside counsel if this feels like something that's a little too far afield for you. So those would be the suggestions I have in the way I think about it.
Yeah, I definitely think talking to the providers is important. I will say on very key things, I would try to get a statement in writing, because I've seen conversations about the way things are supposedly administered, and then suddenly you get a giant invoice that contradicts the conversation. Sure. And that could be a problem. But I definitely agree with that. If anything, just to get clarity, because I mean, I think there are multiple reasonable methods to administer arbitrations. I think bellwethers or MDL styles are great. I think batching, I have some concerns about batching depending on the nature of the matter, but it works great for a lot of companies. Others want to do massive consolidation. That's, again, to Matt's point, something that really sort of suits your risk profile. But the main thing, no matter what you want to know, is whatever my choice is the arbitration provider going to honor that choice? And getting that ahead of time is crucially important. I won't list all the factors here, but things like how fees are done, how stays are honored, what venue is enforced, when they decide to apply certain purported substantive state law, even if the parties agree that it shouldn't apply. I mean, it's a huge issue if your contract with mutual agreement is getting overridden, unless you decide it's not a big deal, but you need to know that ahead of time. So I would try to engage early on that. Matt, on actually that point of some of the substantive laws and how they're impacting the ability to contract with the terms you want. I know you've had some complaints, well justified complaints recently about some of the developments here. If you want to chime in there.
Sure. So we're thinking about the case law and statutory developments at this point.
That's what I'm thinking.
Yeah. So I'm going to hit on just one point, because I think my field of view here is narrowed by my role as an in-house lawyer, previously at Coinbase and now at Kraken. But one thing I saw happen over the last 4 years is, following Bielski, which is the Coinbase case that went all the way up to the Supreme Court and held that district court proceedings in federal court have to be stayed while the appellate court sort out whether a case belongs in arbitration or not. And also in California, this SB 365, which has removed the automatic stay from California law. I'm seeing more and more putative class actions filed in California state court rather than federal court, just to avoid the automatic stay. So I think that's why I think that's such an important development, is just procedurally and logistically, the California state courts are a very different system from the U.S. federal courts, even from the California federal courts. And so if you're not a California lawyer, but you're a global or nationally facing, consumer-facing company, you're going to become something of a California lawyer one way or the other. Colin, what do you think? What are you seeing on the case law and statutory side?
Yeah, you have to pay attention to California. I wish we had some kind of, federal Voting Rights Act style pre-approval for any new court decision or statute coming out of California in arbitration, because they're always preempted by the FAA. They're just outrageous, but they keep doing it over and over again. I had a case that ultimately got resolved, but we were preparing to try to invalidate another one of these California laws, and we had drafted about 10 pages of just every example of a California decision getting struck down as preempted by the FAA. That we're, hopefully one day we'll get to do that and file it in Texas and get a good ruling there. But you have to pay attention to California. There are a few other states that will occasionally pop in, but California is by far the biggest issue. In connection with the arbitration providers as well, another huge concern, again, especially if you can get clarity on this, is that I've had a lot of experiences of arbitration providers applying California law when it does and should not apply. I mean, directly contradicted by state court of appeals or Supreme Court case law, sending it to the provider, and the provider saying, too bad, we find a connection to California, so we're applying this rule, even though it's waived by the agreement, it's not in the case law. So you've got to be aware of this. I would still challenge it, but you want to factor in the possibility of loss in those issues into your calculus. So just to maybe address a few of these on the statutory side, and I know Matt agrees with me here. If you have any sort of pull in Sacramento, do not hold back here. The plaintiffs' bars in Sacramento all the time passing outrageous bills. The California legislators are not arbitration experts who are drafting complicated statutes about the way procedure should work. They're getting handed these bills by the plaintiffs' bar when they lose a certain issue, getting it just pushed through the legislature on grounds of consumer protection, and it's causing outrageous results.
Well, we're seeing that on two fronts, right? One is on process, which is what is the process that should govern arbitration proceedings? It seems like once every year or 2 years, the California legislature in particular passes a new law to amend the California Arbitration Act in some very substantive and meaningful way. So that's one way that the law keeps changing. But the other is on substance. Like, we keep seeing these new substantive statutory causes of action with statutory penalties, private rights of action. And so the type of activity that maybe historically you would regard as the type of thing that a state attorney general or a state regulator is supposed to do, that is increasingly being outsourced to private plaintiffs through new statutes with new private rights of action, with civil penalties that are, you don't necessarily need to prove some sort of culpability. It's just X, Y, Z. You're liable for $3,000 a violation. And that stuff then accumulates and becomes something that the plaintiff's bar is able to go out and tag corporate defendants with. So I think it's important to keep in mind that those legislative developments are happening on both fronts, procedure and substance.
Yeah, no, absolutely. I mean, there's one effort by some of the well-known plaintiffs firms right now. I don't think it's likely to pass this year, but next year, who knows, to actually have California pass a law that would say if terms of service, inclusive of an arbitration agreement or not, are deemed to be unconscionable, and that is proven in court, that will bring a statutory penalty. So you could literally have somebody challenge your terms of service on something like a limitation of liability excess, get that found unconscionable, and rather than it being severed or whatever else it may be, they would get $5,000 for it and bring it on a class-wide basis. I mean, crazy causes of action. I wish there were a way for everyone to boycott California for 2 weeks and then they'd have to fix it, like the wealth tax situation they're doing right now, but that's not realistic. So you've got to pay attention to it. Two more I think people should just be aware of if you have a California consumer base, which pretty much everybody does. Discovery rights in arbitration are going to be a pretty big issue now. California has SB 940, which sort of purports to allow discovery of the nature that would be allowed in court, including explicitly depositions. I have generally found that, and this applies both to discovery and to other issues, just because the arbitration provider purports to apply a rule doesn't mean the arbitrator will. There's a very interesting conflict there. I've had this actually several times with the providers where the provider will say, as a matter of California law, we don't allow this. And you go to the arbitrator, and the arbitrator, usually we're actually California judges formerly, they will say, yeah, that's wrong. California law mandates or disallows this. So the merits arbitrators can be better, but it is hard if you're a merits arbitrator and your provider is saying you are obligated in this case to follow a particular procedure. Just got to be aware of that on the discovery issue. I have not seen, although I've not actually checked the alerts in about a week, so I should probably go back to that. As of 2 weeks ago, there's a new bill affecting California, SB 82, which sort of looks clever at first glance until you take a little closer attention to it. It basically purports to say arbitration agreements just don't apply to almost any of the claims that people face on a regular basis. None of the privacy claims, none of the torts. It essentially misconstrues contract language from Section 2 of the FAA and says the arbitration agreement can only apply to contract claims, and that's it. Even though the contract, of course, in terms of service, applies to your relationship with the user. It ignores that part. Again, plaintiffs bar drafted. The hook they used was that sort of infamous Disney case I'm sure people saw in the news about Disney trying to compel arbitration and sort of I won't go into all the details, but sort of a personal injury related accident in a theme park with a separate arbitration agreement. Reading that as outside counsel kind of seems like the kind of thing where even if you can make the argument, you probably shouldn't. But in any case, that was enough to get this bill passed in California. So there are going to be challenges in many of these cases, I think, starting soon, as to whether arbitration agreements even apply when consent is confirmed. On the case law front, too, it's not just the California legislator. It's also some of the California judges, both in state and federal court. What I would say there in general, though, is that although there are some bad decisions, I think it's pretty important to look closely at who is writing them and whether or not they are binding. So one of the things, I see a lot of right now is people scared of bellwether processes because there have been a trio of decisions out of ND-Cal finding various bellwether processes unconscionable. First, I think the decisions are plainly wrong. Second, they're pretty easy to fix even if they are wrong, if you look at the way they're drafted. But third, and this just doesn't get briefed very well regularly, they're all the same judge. It is all Judge Chen in ND-Cal. I don't have any way of proving this, but it seems quite clear that there's not random assignments in ND-Cal, sort of taking each of the decisions himself. One federal judge opining on California law, that is not precedential in a California state court in a way that the California Supreme Court's decision on an issue would be, subject to preemption issues. And so you should be aware of that. You don't want to be ignorant of those decisions if you're going to implement one of those processes. But I'd read them closely and pay attention to who's writing them, because I think it can be too easy to get spooked sometimes by the reality of outlier decisions. And you want to know which ones are serious and you should really reform your terms right away, and which ones you got to prepare to brief, but are maybe not the biggest issue. Matt,
I think I was going to say, I think that distinction reflects a difference in how judges interpret arbitration provisions and weigh whether particular provisions are unconscionable against what happens in reality. Because I'm definitely one of the lawyers who is afraid of bellwether provisions. But, that's not because of the way things play out in reality. It's because of the way that judges have interpreted them, that they have been hostile to bellwether provisions. Now, what do I mean by this distinction? The distinction is that in reality, all of these mass arbitrations that get litigated in this third, all is probably too much. I expect many of these mass arbitrations that get litigated in this third generation are going to have a snowball-like effect where the results from the first few arbitrations kind of like infect the results for the remaining several hundred or several thousand. And so whether you've contracted for a bellwether provision or not, the first few cases that you let go to a full decision are likely to affect in some way the later decision. So the reality is these cases will likely be litigated as bellwethers, even if judges are saying the explicit requirement to have a bellwether is something that they find unconscionable. And I think it's just reflective of a divergence between how folks interpret provisions and how this stuff actually plays out in practice.
Yeah, I think that's an important part of it. If you get someone like Judge Chen, they know this stuff and they just don't like it. It's a whole different kind of brief to write. Yeah. I do think there is also a tendency, and it's an easy trap to fall into for good reasons. When you are in-house or outside counsel who are really in the weeds on these things, to assume everybody has done a lot of them. It's pretty easy to construe a lot of very good faith measures as devious corporations to someone who has not dealt with a lot of arbitrations. And one would imagine, oh, of course, all these federal judges know these issues. But many of these judges, you take a look at their analytics, and they've never had a motion to compel arbitration. They're getting the first one in front of them. So a lot of this really has to be spelled out, both in the case law, but also, there are. I'll plug one of them. And the Chamber of Commerce's mass arbitration research is phenomenal. If you have not read that and you're dealing with these issues, go download it. There are other sources as well. But you've got to explain for a new judge what is actually happening, how you're trying to resolve cases in the merits the way that was intended. And if you don't, it does happen that there are actually pretty good judges who reach bad decisions because there's too much assumed of their background knowledge there. Matt, do you want to talk about with this context how you feel about arbitration versus class actions generally now?
Yeah, I was going to say, folks in the audience here have listened to us kick around a lot of strategy around how we think about mass arbitration, and so much of it is procedural. And I'm sure a lot of the audience is thinking, why the heck would we agree to arbitration at this point, given that the procedure around it has more or less developed into a practice area of its own? And I think the answer is it really depends on the client. I think there are some companies out there, Amazon is a good example, where they've made the decision to get rid of arbitration agreements, customer-facing arbitration agreements, and just let these things go forward in court. So here's how I think about, the factors to consider, and then you need to decide what to recommend to your own clients. So here they are. On the arbitration side, I think the pros are, if you've got a class action waiver, those are likely to be enforceable. So you're able to mitigate class action risk. I think you get more privacy and confidentiality out of arbitration. You get more flexibility, especially following COVID, where every trial lawyer became a video trial lawyer with these remote proceedings. Now, post-COVID, I think folks accept that it's okay to have preliminary hearings and in some cases take live witness testimony over Zoom. And look, you could do that sometimes in court, but it's way more flexible in arbitration. I also think arbitration is way faster. The whole case can be resolved in many cases in 6 to 18 months, which is impossible for most courts. And lastly, you get finality. And that cuts both ways, but it really is finality unless you contracted for a private appeals process with arbitration. The cons with arbitration, one, and I think this will surprise a lot of people, I think arbitration is really expensive. I know that the historical reason to do arbitration is because it's less expensive than federal courts. Candidly, my experience has been many of the arbitrations I've been involved in turn into litigation about process. And that's something that the federal and state court system really will not tolerate. They want to keep cases moving. They have strict rules of procedure, and arbitration just doesn't have that, and that creates more cost. Another con is the snowball effect that I mentioned earlier. Whether you've contracted for a bellwether process or not, those early decisions in a mass arbitration campaign are going to weigh heavily on the later trials to go forward. I also think arbitration is much more unpredictable than courts. And for this one, I'd kick it to the arbitration providers to really dig in on this and consider some of the substantive rulings that arbitrators have issued. Maybe solicit feedback from both sides, from the plaintiff's bar and the defense bar, around how they feel about the quality of the decision making that takes place in arbitration. I do think that it's a bigger risk in arbitration. And last, as we've talked about, tons of litigation about process. On the court side, the pro is you get certainty, right? If you feel confident about what the law is supposed to be, you've got appealability, you've got a number of procedural rules that kind of steer the law into a singular direction, and then you can just go back to your client and apply it. It's much more merits focused, I think, than arbitration, which I know is not the way that arbitration wants to be. But the practical reality is that court litigation seems to be more focused on how do we get this case to really resolve on the merits, rather than a lot of litigation testing the process. The cons of court litigation, look, it's going to be a public proceeding. The public has a right to access in the courts. And there are good reasons why plaintiffs and defendants would want privacy and confidentiality. Courts tend to be slower. You may be in a court that has a rocket docket, but in the main, courts take years to resolve cases, not months. And lastly, the class action risk. There are some companies that have said, no, we'd rather have class actions than mass arbitrations. And again, I think it's something that you and your clients have to consider carefully on a tailored basis.
Yeah, the only things I'd add to that is that, because I think there are pros and cons as well, and I think it's totally reasonable to go either direction. I generally, for most companies, still prefer arbitration as long as they have thought through their terms. And the main reason is that even in the previous generation of mass arbitrations, the worst settlements I ever had to bite my tongue and agree to with a client that involved basically $2,000 per filing jams bills with very little hope of getting that undone. The worst of those were still nowhere near the occasional 9 or even larger figure class action settlements you see for high statutory damages cases. Those are what really freak me out. And I think I recommend companies do this. I've done this sort of across clients I work with, but if you have more data within your particular company, it can be very valuable. Just chart. If you switch an arbitration agreement at some period of time, and or you have peers in your industry, chart settlements over time. So when I look at this, because let's say in 2022, right, previous generation of mass arbitrations, you get a just disastrous outcome because of the filing fee issue. If you just look at that 1 year, the class action looks much better because you didn't have to pay that amount, and you might have had it, dismissed on an early Rule 12 motion. Yeah. When I look at all of those events over the last few years, the average class exposure would have been significantly higher. But again, I think it depends on the nature of the claims you're going to face. So personally, I think if you are prepared for arbitrations, you have your process set up, I would rather take the occasional arbitrator who has no business adjudicating a dispute, which does happen sometimes. And I would rather deal with that than the risk of an outsized class settlement. In particular, just the occasional district court judge who lets everything get past a motion to dismiss that you can't appeal, that subjects you to discovery, that the claims against you might actually be the least of your concerns at that point, because who knows what else is going to be found in there. So it does vary, but in general, I prefer to avoid the risk of a 9-figure class settlement, even for all the issues of arbitration. I also, without going too far in the weeds on this, you can use a lot of new tools, including AI tools, to dramatically increase the efficiency of your arbitration process. So when you're dealing with mass claims, when I'm doing these, I don't write 10,000 briefs. I will write one brief. I will write individual differences for the claimants that can be pulled out by analytics of the company, and you can just use a little easy free piece of software that merges them into new briefs for you. I mean, if you were doing that without preparation, then yes, it makes it much more expensive. But if you know these are coming, you can get the benefits of arbitration while dramatically diminishing the costs.
Well, on this front, I want to give the arbitration providers some credit. I think the whole reason why we're able to have this panel and talk about what's working and what's not working in these mass arbitration proceedings is that all of the major arbitration tribunals have instituted mass arbitration rules and importantly, mass arbitration fee schedules. I think in the absence of doing that, there would be very few corporate defendants who would say, yeah, I'd rather have a $70 million bill before an arbitrator is even appointed to stay in arbitration rather than take on the risk of class actions. So I think arbitration providers, they realize that that's a problem and it needs to be addressed. And kudos to them for beginning to address it with these new fee schedules and with these new rules. I have my own criticisms of the fee schedules and the rules, but put that aside, I think that's why it really is a decision that has to be tailored client by client, consideration by consideration, what makes sense for you. This is probably a good point for us, Colin, to transition onto what we're seeing on the merits. And I'm just going to just briefly kick things off on the statutory penalties, because to me, I see that as like the big thing that makes mass arbitrations possible is if you've got cookie cutter claims that are identical one after the next. That's the way that you're able to easily aggregate 10,000 of these things to be filed at once. And so I think both outside counsel and in-house lawyers for corporate defendants need to be mindful of the latest statutory schemes that have private rights of action with statutory penalties. You may be wondering, what can you do besides staying abreast of the developments? What can you do that's proactive? And to that, I'd encourage everyone on the in-house side to have a stronger cross-functional engagement with your product and policy teams. I don't look at the litigation work that I do at Kraken, nor did I look at it at Coinbase in a vacuum of just managing cases. I look at my responsibility as I have a particular field of view, but there are other folks on my team who have different fields of view and different capabilities, and engaging your policy teams and your product teams about what you're seeing in the litigation landscape, what these developments look like, what they mean for the business, and what sort of changes we would want to see in order to put the business in a better spot. I think that's critical to being an effective counselor to your business.
For what it's worth, Matt, especially in privacy cases, which are some of the worst in terms of statutory damages, in any case where I see serious exposure, by far the most common result is that it was somebody acting completely diligently in product or engineering who implemented some new technology or some new tool, had no idea it should even trigger legal review, and that's what caused the issue. And you can't expect every single person in your company to be assuming that states are passing crazy laws with giant statutory penalties. It's hard enough for the lawyers to keep track of it, let alone for the engineers. So I see those a lot. I've got some more thoughts, Matt, on other areas, but I want to let you continue on that if you got another note there.
No, well, I see we're coming up at time, and I wonder if we should kick it over to the audience for any Q&A.
Happy to do that if there are any questions there.
Yeah, and for that, Marco, I don't know if it's best for us to just stand by and see if folks want to ask questions in the Q&A panel, or if people are able to raise their hands. But for the folks in the audience, at a minimum, both Colin and I have the Q&A panel open. So if you want to throw a question in there, we can answer it. I see one of the audience members has their hand up, and I wonder if we're able to give them an opportunity to grab the mic. Let's see, what does Marco say? Probably best to...
Oh, I think so. I think I did see a hand, but I think it has to be dropped in the
Q&A. Yeah.
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 Oh, go ahead, Matt.
No, I was going to say, I don't know if folks in the audience can see, but if you go to more and click on Q&A, you could then ask a question in the Q&A panel.
Maybe while we're getting that question put in there too, yeah. I'll just mention to double down on what Matt said, statutory damage claims huge, especially in the privacy space, but not only the privacy space. Another area that I'm seeing increase a lot are it's like spelunking for every state that has some kind of statutory penalty for supposed unfair competition claims. Usually these claims are extremely weak. Given the reality of the diversity of arbitrators, I will never say you can win a particular issue 100% of the time. You can find someone who will rule against you. I'm just not aware of anybody ever having lost one of these claims, but someone's going to find a plausible unfair competition claim at some point and pull out an unexpected state that has a penalty there. So watch out for those.
Yeah, I see we've got one question. Yeah. So, one of the questions, if you can please elaborate on the 9B insertion pros and cons. So, look, I actually think there are really very few cons to putting something like this in. To me, the main con of inserting any mass arbitration specific term is, will a court not only invalidate the term, because I'm less concerned about the term itself being ruled unconscionable, but will a court take that term, find it unconscionable, refuse to sever it from the underlying arbitration agreement, and then send the case to court for further proceedings. So that, to me, I see as the con. And I don't think the explicit inclusion of a federal rule of civil procedure that deals with improper conduct is onerous or unconscionable. I feel very confident standing up in court and defending the federal rules. And of course, the pros to it is that it's a useful hammer. Many of the arbitration providers, they don't have explicit terms around sanctions and improper conduct. They leave the resolution of those issues in the hands of arbitrators. My experience has been that arbitrators are more hesitant to sanction improper conduct than courts, especially state courts. I think state courts are much more eager to do this than let's say federal courts. But again, that's just my experience. So I'd say on balance, I think including it makes sense. For examples of this, I know that Coinbase has one. So if you look at Coinbase's user agreement, there's likely a specific 9B term in there.
9B can get claims thrown out before they proceed. I mean, the most irritating, again, there are claims that are, I guess the way I would put them is objectively meritless and that no one was harmed, but legally they have some merit to them because they're annoying statutes in the books, which is just reality. The most irritating, though, are the claims that they're meritless in every respect, including legally. And for those, requiring them to actually meet a 9B standard to articulate what the claim is, not only can you get it thrown out if they fail to back it up, but if they don't meet that pleading standard, you can get it thrown out administratively before you owe a bunch of fees for a frivolous case. And then if it does proceed, and let's say they try to do the maximum pressure, I want depositions, et cetera, you then have something real to get discovery on and depose the claimant on. And it's almost every single time very quickly revealed they have no idea what claim they brought. They clicked on an ad, they thought it was a settlement, and basically their own plaintiff's counsel misled them. So 9B has all kinds of benefits.
Yeah, and I wouldn't expect any further developments on that from the arbitration providers because candidly, there shouldn't be, right? There are a lot of folks who file pro se who don't necessarily know how to frame their claims. And so given the latitude that's afforded arbitration providers, given their objective of giving a quick and efficient process for resolving claims, I wouldn't leave it to the arbitration provider to institute those types of things. So if that's something that you want, you've got to put it in explicitly.
Yeah, I did that. And then also, to Matt's point about sanctions, I like making the attorney certify a good faith investigation too. It's really nice to tie them to it because they never do. I mean, they never investigate their actual client's claims, and it doesn't provide a lot of relief to say you violated your ethical obligations if you're still having to pay them because you want to avoid fees there. But if they're actually on the hook for it, they've signed something, the penalty can be imposed on them. Very useful.
Yeah. Do we have any other questions from the audience? One question is the CLE code.
Marco, I think folks are having difficulty finding the CLE code if you want to read that out. But in the meantime, I think I saw another question come in. What identity verification or pre-filing requirements can we add to terms to stop law firms from filing thousands of claims for people who aren't actually customers?
Well, that one can be fun because if so the answer is nothing, right? There are no terms for you to put in for someone who's not a customer. But if someone does that and files thousands of arbitration claims against you, you could just take the position that we don't have an arbitration agreement with this counterparty. And so if you don't have an arbitration agreement, they have to sue you in court. And that gives you the ability to join all of those claims and all of those people in a single proceeding in court. So I think if you're facing that type of threat, you may want to consider just arguing to the provider that you don't have an arbitration agreement. And providers pretty regularly dismiss those claims because they'll ask to see the arbitration agreement and no one has an agreement to produce.
Well, one thing I'll throw out for companies that have the sort of resources and long-term time horizon to do this, which is not everybody, if you have the ability to integrate the arbitration dispute process into your general customer complaint network, that is extremely useful. It blocks the plaintiff's counsel from filing these fake claims. Someone goes in, they complain about an issue, and then if it's unresolved, they can start the arbitration process in their account. It verifies them as a real user, and it prevents these massive copied and pasted nightmares.
He's just an arbitration provider.
I think the person who just asked for, can you suggest an arbitration provider? Maybe Matt and I should talk to you offline, and we'll give you a long list of pros and cons.
Yeah, they're all great. We love them all equally. I guess the one thing I would want to reiterate, though, separate and apart from, happy to chat offline with anyone who wants to talk about it. But again, I think there's just a spectrum of providers that you got to consider. I think there are folks who are really trying to innovate are on the cutting edge. And I think there are folks who have already built up a really solid reputation, have large volumes of potential arbitrators that they could deploy for these types of claims. And you gotta decide what makes the most sense for your company, where you are on that spectrum. Cool. Well, I think that's, I see we're at time here, and if there are no more questions, we could probably kick it back to Marco here.
Well, thank you both for that fantastic discussion and the benefit of your time and expertise today. On behalf of the Federalist Society, I would also like to thank you, our audience, for joining us. We greatly appreciate your participation. For anyone seeking CLE credit, the attendance reporting form has been linked in the chat box. Please complete this form now. If you missed the link, it will be emailed within 1 day of the webinar. A COA with your calculated CLE credit will be emailed to the address you provide within 1 week, along with any pertinent CLE credit reporting information for your state. If you do not receive this follow-up, contact us at cle@fedsoc.org. For information on more upcoming events, please visit our website or all major social media platforms @FedSoc. On that note, we are adjourned.